Hey, welcome back, folks. It's always a pleasure to be here. Today is going to be a great afternoon with everyone. We're going to talk about Roe v. Wade, abortion rights, the Supreme Court. My goal today is to make sure you are very informed about how the Supreme Court works and what went into their ruling. This is the opinion of the court. I should say opinions of the court, because there was a majority opinion, there was a concurring opinion, there was another concurring opinion, and then there was a dissenting opinion. So I read all of it, and I want to make sure that you are kind of empowered to kind of understand, the arguments that the Supreme Court is making, that the Congress has made, and kind of what goes into this. All right, you're going to get the legal eye perspective, so that when you discuss this matter, you're more empowered to discuss it. Okay. I thought of a funny joke. All right. So today I went to the gas station. All right. Gas is right now it's a little under $7 a gallon. And as I was putting in gas and when I was done, I just felt like screwed over. I felt like violated financially. I felt like I was taken advantage of. I just felt miserable, right? And then it hit me. Oh, this is what civilians feel after they hire a lawyer. Right? My fellow lawyers, if you want to know how the civilians feel after they hire us, go to a gas station and fill up your car. It finally hit me. My gosh, I hate lawyers. And then the other joke I may have once said several episodes ago. This lawyer walks into a law firm and he's super, super, super excited. He's like champagne and pizza for everyone. And he's like jumping up and down. They're like, what happened? Why are you so happy? He's like, I won my big appeal. They're like, you won? He goes, yes, my client had 5 life sentences. And because I won the appeal, I got it down to 4 life sentences. All right. Freaking lawyers. Okay. So, and then another thing I had this past week, a lot of people ran a lot of things by me, this run it by my lawyer. I got a lot of calls. One of them that stuck out was this guy. He called on behalf of his son. His son is 27 years old, and his son has these kind of different like mental type of things. And sometimes he kind of goes off the loose end and just does things that don't make sense after he kind of, gets back on his medication and whatnot. And during the time that he kind of went off his medication, he somehow ended up at a big car dealership. And somehow he bought a car. Okay, he has no money, bad credit, and they sold him a car. And what he signed, the contract he signed, it was for the $27,000 car, right? All finance, 100% financing, for like a used Honda, okay, for $27,000. So it was overpriced as is. And then somehow the final price was $53,000. So the car was $27,000, and then there was another $26,000 in fees. They managed to sell him. I had to write some of this down. A loan cancellation agreement. They which was like $1,100. They somehow got him to sign a tire warranty for like $1,500, a theft patrol protection in case his car gets stolen, another $1,500, and all these different types of services for the car, like $3,000 each and $3,500 each. It was crazy. And there was like so much more. And so it's going to be a tough one. I looked at everything and I said, okay, we're going to have to find a way to get this kid. I know he's like about 25 or 27. Was it 25 or 27 in that range? But I'm old enough to still call him a kid. So we're going to have to find a way to get this kid out of this contract. Okay. So, I kind of went over it a little bit and, so I'm kind of talking to those guys. But I was happy that they called me for the run it by my lawyer. And then I want to address, there's been some great comments in the past episodes. And, our producer, Zeke, he had a good idea of me taking a look at one of these comments. One person wrote, and this is in regard to the episode of my boss made me wear a rainbow during Pride Month. And this one person said, I'm going to leave out the bad words. God, this piece of S is starting to piss me off. Is piss a bad word? I don't know. For the millionth times, love who you want to love. Dang it. He didn't say dang it. No one cares about your sexuality, but don't force that stuff, okay, is that a different word, down everyone else's throat. This is kind of the idea, okay, fine. If somebody wants to be as gay as you want, just don't show off, right? And I've heard that a lot of times. I mean, gosh, it's got to be, I've heard that a lot of times. I don't know. I don't know if the same applies, if they get just as upset if heterosexuals, show off their pride, the princess, when I was a kid, the Princess Diane wedding, everyone in England was like, yeah, heterosexual marriage, I don't know. So obviously there's this commentator, he or she goes by Episode Gaming Play, just said, be gay as long as you're in the closet or you don't show off. Okay. Anyway, so interesting comment there. Now we're going to talk about abortion and Roe v. Wade and, all of these different kind of constitutional arguments. And by the way, this is the opinion of the court that was issued on June 24, 2022. 213 pages is the Supreme Court's opinion. And I had the pleasure of reading the whole thing and kind of, and now I'm going to kind of put it in a way that you could understand what's going on. And it's not, it's not as easy as this, it's women's rights or, it's, whatever, the baby's rights. It's a kind of a complicated decision that I'm going to walk you through so that whether you're against it, whether you're for choice, whether you're pro-life, whatever you are, is fine with me. I just want to make sure you're informed about how the court went through this very important decision, right? Okay, so first off, and the court makes a point of explaining this and, the procedure of the abortion, right? So the court is saying that, kind of in an early pregnancy, the medical procedure of what the court is saying, killing the fetus is, you take this kind of you basically suck the fetus out, right? And then when you suck the fetus out and then it's not getting any more oxygen or nutrients and it's obviously going to die, right? So that's the kind of procedure in the very, the first 12, 13 weeks, let's say. And for the doctors listening, forgive me. I know this is a bad summary. This is just like a very small summary of it, right? So anyway, and then the court also says about the pills that could be taken in the first, several weeks, and that is kind of does the same thing, except that it kind of it administers something that kind of kills off the nutrients or oxygen to the fetus, and then it obviously won't be brought to term that way. Then the court, and it doesn't go into that much medical detail. That's why I'm not going into that much medical detail. They just kind of explained it really quick. And that after the first 12 or 13 weeks to terminate the pregnancy, it's kind of a little bit more complicated because by then, after 12 weeks, the baby's obviously bigger, right? So at that point, it's not just a simple kind of suck it out. They call it dilating everything, and then evacuating the fetus. And to do that, there's a little bit more kind of, pulling, I guess you can call it. I know it sounds, I know, but I want to make sure you're understanding how the Supreme Court is kind of deciding all of this. Okay. And then, so that's a kind of more complicated process, and it's they call it the dilating and evacuating. After that, if it's a very advanced pregnancy, then it's a very serious process. It's a very to get the fetus out of there. It's not as simple as sucking it out. It's not as simple as evacuating it, as they call it. It's it was a kind of more treacherous process. Okay. And I think my gut feeling, obviously, why the court did this is so that they can kind of, in the opinion, they're starting to justify, things like, well, the unborn have rights too, And so that's kind of why I think the court kind of gave some of that medical kind of background. Again, the court didn't go into a lot of medical background, and I kind of just explained some of the stuff that they said. There's also the court didn't go in as much opinion in this one. There's also been these weird cases or disputes about what to do with the fetus after it has been terminated, or after the pregnancy has been terminated. There's all these different disputes. Do they incinerate the baby? Do they put it in with the general medical waste? Do they what the heck do they do? Right. So there's been a lot of debate about that. And also there was this really miserable case in Indiana. This one doctor, after he died in the year 2019, he was retired for a while. So after he died, his family was going to sell his house or whatnot. And they found over 2,000 disposed fetuses in the house. Apparently, this doctor, after doing the abortion, he would just collect it and he would keep the fetuses somehow at his house. It was such a disaster, and then the police ended up investigating. The guy had already died, right? But they were investigating. They were trying to figure out how the hell this happened and why he collected these and why nobody even thought about how they're supposed to be disposed. And then even in his car, when they got his car, there was fetuses in the trunk. It was disastrous, right? So anyway, I'm going over this because different courts have kind of discussed these issues when they are deciding these cases, okay? And of course, there's also they go into that, if a woman cannot have an abortion or that after she wants to, kind of the what the imposition in terms of the pregnancy and the healthcare decisions that she has to make and the cost, and then the effects for her whole life, right? So we are obviously talking about something that these courts have kind of strained to decide, kind of to interpret the law and to make these opinions. Okay, so now that being said, to the Supreme Court case, back to the Supreme Court case. So the Supreme Court justices, the majority of them, okay, the ruling goes like this. They start off, they address Roe v. Wade. It was a 1973 decision. And that decision in 1973 said that the Constitution provides a fundamental right for women to have an abortion, especially, before the baby is viable, right? And so that Supreme Court decision in 1973 basically said, because a woman has that right, and that fundamental right, is derived from, it's her health, it's her choices, it's her privacy right that, so that nobody else has the right to know exactly what she wants to do with her, medical decisions, with her body, that type of thing. And because the Supreme Court in 1973 made that ruling that is a constitutional right, then after 1973, no state is allowed to make a law against that. So they couldn't make abortions illegal, in the first, 13, 14 weeks, they couldn't make it illegal. All right. And I say 13, there is a little bit of, ambiguity, right? Because it's not like Roe v. Wade said abortions are always allowed under all circumstances, even at freaking 9 months of pregnancy. No, that's not what it said. Okay. So that's why this court made it a point to say that. Well, they said, well, this is going to be a tough opinion to keep working because the technology changes, the viability changes. Sometimes babies are viable at 3 weeks. Well, not 3 weeks, but you know what I'm saying? It's everything is changing. So it's hard to kind of sort out how we're going to do this. Okay. So anyway, So after 1973, that became, so to speak, the law of the land, all right? And the way it works goes like this. The Supreme Court in 1973 stated that because this is a fundamental right and it's rooted in the Constitution, therefore, and then the 14th Amendment says that if there are any sort of fundamental rights, no state can abridge or take away those fundamental rights. So no state in the country had the constitutional authority after Roe v. Wade to make a law that outlawed abortions in this early, for the very least the first 15 weeks or so, right? So that became the law, right? Now, what this court said is that decision was an absolute disaster, okay? This court said that now we're going to get, like a little bit deeper into the actual legal wording of the Supreme Court's decision. To start with, the court says that, look, in the Constitution, there are a lot of rights. And the important rights, so to speak, are the rights that are specifically detailed, right? Is that a redundant term? Specifically detailed, all right? The meaning, like the First Amendment, the right to free speech, okay? The Second Amendment, the right to bear arms, okay? The Fourth Amendment about when searches can be done. The Fifth Amendment, no, you don't have to self-incriminate yourself, all right? The Sixth Amendment and the Seventh Amendment, the rights to, in a criminal prosecution, you have the right to have your attorney. You have a right to a jury of your peers. The Eighth Amendment, no cruel and unusual punishment, all right? So those are some of the actual very specific rights in the Constitution, all right? And then, the court says it's not the joke or whatever. They're like, well, we looked through the Constitution and we did not find in anywhere the right to an abortion, right? This is what the Supreme Court is saying. So what they said is, all right, so right out of the gate, we have the textual rights, okay? And then we have rights that are not specifically mentioned, okay? Then there has been, over the several decades and centuries, there's been laws that said, okay, there are rights that are not specifically mentioned in the Constitution, but they are fundamental rights. Things like, same-sex marriage. The courts have ruled assisted suicide is not one of those fundamental rights. Things like certain educational rights and things like that. So those rights were kind of, the way that works is, according to the Supreme Court case, and it's the majority opinion, so this is the law of the land, right? The way that works is if it's not a specifically mentioned right, then there has to, for it to be a fundamental right that is something like, well, the Constitution gives you this right, even though it's not mentioned, it has to be some sort of fundamental right. So then what the Supreme Court says is, well, let's look back at history, all right? And then the Supreme Court goes over centuries of history. And it goes, man, one of my pet peeves is when they go back and they start citing old British cases, all right? I don't know why. It's like, dude, we are not in England, right? But nonetheless, they always go back, and when they go over the history, they go back to the England. It's like, that's our mother law, So they go back that far, right? And they go back to, I think the 1200s even, right? So what they do when they go back to the 1200s is basically they're citing, first of all, the laws in England and these old legal scholars like William Blackstone. Here's a picture of William Blackstone. The reason why it's a painting that you're looking at and not a photograph is because William Blackstone lived in the 1700s, okay, in England, and there was no photography. So these are, okay. so we're not going to have photos. So here it is. You look at it, William Blackstone in the 1700s. Our friend here did, okay, so there's no photograph. So they're even citing his kind of philosophy and what he was writing about what the common law means, like back in the day, before there was like a lot of statutes, the common law was just basically how the courts interpreted the law. All right. And back then, before United States was, the United States, right? Abortion was not really legal. Okay. Now, why do I say not really legal? Because it wasn't. It was illegal after, like some cases cited this thing about the quickening. What the heck is the quickening? It's kind of like when the baby starts moving and stuff. Okay, so when the baby starts moving and stuff, that was kind of the theory was this must be when the baby could live on its own, blah, blah, blah. And after that, there was a lot of laws that kind of distinguish that once that happens, then any sort of abortion after that could be even punishable by a crime. Okay, so this Supreme Court, what it does is it cites these old laws that said all of that, right? Then this Supreme Court said that kind of like earlier than this quickening, there wasn't really a criminality thing if you have an abortion like early on, okay? But the Supreme Court did say that it wasn't condemned, but it also wasn't condoned, all right? What the heck? I mean, if you ask Joe Samo here, if it's not illegal, darn it, then it's legal, right? But this Supreme Court said, no, it was not illegal, but it wasn't also legal. It wasn't like encouraged, I guess, okay? So that's when they're citing all of this old law. Why are they citing all of this old law? Is because of the United States Supreme Court majority here is saying that if it's not a particular textual right, like the self-incrimination, you have a right to an attorney in a criminal case, you have a right to a jury in a criminal case. If it's not a particular texted, no, not like an iPhone text. If it's not a particular texted right, then it has to be somehow it was a fundamental right back in the day, like before these laws were written, right? Or before the Constitution was written, or before this amendment was passed, things like that. Okay, and then what they're saying is, no, the abortion was not a fundamental right, especially in Old England. Then they went on to say, okay, with the states, even when the states were starting to be formed and early on in their legislation, more or less, a lot of states had laws that just completely banned abortion, even like the, second week or whatever. And then some states banned it like after the quickening, like later on in the pregnancy. So the Supreme Court is basically saying that, all right, so the right to an abortion is not a text. Like there's not an amendment that says all women should have a right to abortion. Okay, so I think we all of us agree that it's not like the text of the Constitution, right? Then the Supreme Court, I'm going into pain and detail, and hey, don't yell at me. I had to read like freaking 100 pages of this kind of old school stuff. It maybe is even more than 100 pages of this was kind of like describing this old school stuff, because then they also cited the laws of every single state before Roe v. Wade, okay? And what they're saying is, even after the states were formed and long after they were formed, all the way up to Roe v. Wade, most of the states did not have anything that gave a right to an abortion. In fact, most states, it was illegal after, a certain, amount of weeks. And then some states, it was illegal always. And there was a few states that maybe didn't make it illegal. Okay. So basically then what the Supreme Court is saying is that the right to an abortion, like I said, it's not a text of the Constitution. And apparently the Supreme Court is saying it is not like some sort of deep-rooted fundamental right, okay? So that is what the Supreme Court says. Now they said that Roe v. Wade was incorrectly decided, and all of the cases that affirmed Roe v. Wade was properly decided. And there was a very big Supreme Court case in 1992 called Casey that reaffirmed Roe v. Wade. And then this court said that that was also wrong. One thing that I've always wondered, okay, the Supreme Court, what they're supposed to do is interpret the Constitution. Okay, so there was a class in law school, when I went to law school in Berkeley, it was called Constitutional Law. Okay, and there was another class called Constitutional Law 2, all right? And basically, it's the interpretation of the Constitution. So these judges are not, they're interpreting the same dang language as they did in 1973 and again in 1992. So apparently, these judges are saying that the judges from before must have failed constitutional law because they freaking had it wrong for 50 years. For 50 years, they had it wrong. And that the dissenting opinion of 3 judges also have it wrong. So apparently, those 3 Supreme Court judges that wrote the dissenting opinion did worse in constitutional law class than Joe Samo did, apparently, right? I don't know. I mean, that's what's going on. That is what they're saying. Literally, ding, 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 ding. Remember that word? Literally? You don't have to ever say it, but they literally said the other judges don't know how to read the freaking Constitution, apparently. Okay? And now, okay, what do they go to next? What they go to next is this principle. It's called stare decisis, okay? The way I could remember how to spell it is stare, like you're staring, and then DEC, ISIS, all right? That's how it spells, like a Latin term, right? So the theory of stare decisis goes like this. It's basically when something is settled, when there's a law that's settled by courts, then you don't want to overturn settled law, okay? And there's good reasoning behind this, and that's basically is because the lawyers, politicians and policymakers and city makers and mayors and governors, they want to know what the freaking law is so that they could, plan their lives and plan the society and make rules and pass rules and all that good stuff, right? So you have to know what the law is, okay? In fact, there's a theory with lawyers and judges, and it was in the Supreme Court in like older decisions. It said it was like the law being settled is more important than the law being settled correctly. All right. What that means is we want to know what the freaking law is. And that's even if it's a little wrong, it's more important that we know what the law is so that we could plan the society and plan the rules and all that other stuff I said. It's more important that it's settled than it is that it's settled properly. Okay. So now the court has to address that principle of stare decisis, because there's a theory that even if the 1973 Supreme Court decision was incorrect, that they should leave it alone, because once you start changing it, darn it, then what's going to happen in 10 years from now? We're going to have new justices maybe, and maybe they're going to change it again. And then what happens then, whatever, then a Democrat wins and a Republican wins, and then every 10 years it's going to shift. That's not supposed to be that way. I mean, it's the same freaking Constitution, right? So it's not supposed to continually change, right? So that's the theory of the stare decisis. This court went against that, all right? That's a big deal. The opinion of the majority in terms of the stare decisis, I think a lot of lawyers, okay, take issue with this part of the Supreme Court decision. And these are lawyers that are pro-choice, pro-life. This is the part of the Supreme Court decision that's kind of a little out there. And it has, the funny thing is that it doesn't have that much to do with whether you're pro-life or pro-choice. It's this theory of stare decisis. Like they're overturning settled law, which is a big no-no. And then the Supreme Court says this. They said, and they're correct in the sense that we can overturn previous Supreme Court decisions if there was a serious violation of the Constitution or a serious like grave injustice to humanity. And if there's a previous decision that was so bad, we can violate the idea of stare decisis, and we can overturn previous United States Supreme Court decisions. For example, the most popular example, and it's cited in this case, Brown versus the Board of Education of, and you want a little trivia, what city was it, Brown versus the Board of Education? It was the Board of Education of what city? Topeka, Kansas, all right? So in 1954, the United States Supreme Court in Brown versus the Board of Education of Topeka, Kansas, ruled that the rights of, segregation and segregating against, races is unconstitutional, and they overturned a previous decision, a Supreme Court decision of Plessy versus Ferguson. And that previous decision said we can segregate and we could separate the races as long as it's like equal, So these, the black people have their own restaurants or trains or hotels, and the white people have it. That's fine as long as it's separate. We could separate them as long as it's kind of equal, the stuff that they have. So that was a previous Supreme Court decision. Even with fundamental rights, we can separate the races and we could segregate. Even with fundamental rights like voting or education or whatever, all this other stuff, right? All the other rights, sorry. Okay. And then Brown versus Board of Education said, in a case where the black community was going to schools that were inferior, they said, no, this whole theory of keeping things separate but equal for fundamental rights is unconstitutional. And we are overturning this horrible precedent of Plessy versus Ferguson. So this court said, are you folks ready? Are you sitting down? Okay, be careful if you're driving. This Supreme Court said that the 1973 Roe v. Wade was just as wrong, or just as bad as Plessy versus Ferguson. It was just as wrong, in terms of constitutional analysis as separate but equal. Like, whoa, that's pretty big. Other cases, by the way, of the United States Supreme Court overturning previous law was like there was cases where they said, okay, we could apply the death penalty if somebody committed a crime like under 18. And then later they said, no, that would be a violation of the Constitution if the crime committed was under 18 and, we can't apply the death penalty. So that was another example of something that was overturned. Another thing that was overturned by the United States Supreme Court, there was cases that said, no, a state can discriminate against gay couples by not allowing gay couples to be legally married, right? And then a Supreme Court decision in 2015 overruled those previous decisions, saying, no, it is a fundamental right for same-sex couples to be legally married. So now you cannot discriminate and not allow a same-sex couple to be married, okay? So what this Supreme Court is saying basically is that the Roe v. Wade was so wrongly decided that it is okay to overcome this principle of stare decisis. I think, and like I said, look, pro-life, pro-choice, it doesn't matter. Like that one is the big one in terms of how the Supreme Court justified it, okay? I do want to say, I've been reading a lot of people and a lot of the journalists and commentators saying, oh, when these particular justices, when they were seeking affirmations to become a Supreme Court judge, that they lied under oath by saying that they're not going to overturn Roe v. Wade. Okay, here, let's take a quick listen to a couple of their what they said.
About Roe v. Wade is that it has been reaffirmed many times over the past 45 years, as you know.
Again, I can't pre-commit or say, yes, I'm going in with some agenda, because I'm not. I don't have any agenda. I have no agenda.
That courts in general should follow their past precedents. And it's important for a variety of reasons. It's important because it limits the power of the judiciary.
To try to overrule Casey, I have an agenda to stick to the rule of law and decide cases as they come.
Again, I would tell you that Roe versus Wade, decided in 1973, is a precedent in the United States Supreme Court. It has been reaffirmed. The reliance interest considerations are important there.
Now, I'm going to make one thing I absolutely say, and I will argue this like tooth and nail. Those justices did not lie to Congress, okay? They did not say that they were not going to overturn Roe v. Wade. They said, it's kind of like this. If the Congress members would say, oh, do you think Roe v. Wade is the law? They said, yes. Do you think Roe v. Wade is well-settled law? They said, yes. Do you believe in stare decisis? They said, yes. It's a very important principle. And then that was it, the questioning. I don't understand why. They never went so far as to say, are you going to overturn it? Do you think that there is justification to overturn Roe v. Wade? And they didn't go that far and then have a justice say, I will overturn it. Us lawyers, judges, they're very, very careful in what they say. It's almost like saying, do you think Roe v. Wade is good law? And then the justices said, yeah, it's good law right now. Okay, that's kind of what happened, all right? So they did not lie to Congress, okay? That I will, if anybody thinks otherwise, let me know, quote something somewhere that says otherwise. All right, so that is how it comes down. So they said that the previous law was so bad, it was just as bad, and they said this in the opinion, Roe v. Wade was just as bad as separate but equal, all right? That's how wrong Roe v. Wade is. Okay, now, and then in a concurring opinion, the way it works is there's the opinion of the court, and that's whatever the most justices sign off. So that's everything I said was the opinion of the court. A concurring opinion is like, it, how do I say it? It agrees with the opinion of the court, but then they just want to add another couple cents, okay? And Justice Clarence Thomas did that. He wrote a concurring opinion. So he joined in the opinion of the court, and then he wrote another opinion, just like a little add-on, okay? It's like in an argument, and then your mom or dad says, and you know what else? So Justice Thomas says, and you know what else? He wrote that if only the rights that are written, the specific rights that have a text in it are the substantive rights. That's it. No other rights exist, basically, unless it's actually written in the Constitution. And then he said the 14th Amendment, all it does is it applies those actual rights to the states, kind of like, the right to a jury trial. Every state cannot violate that right because it's a text of the Constitution. And he made it clear, saying all these other so-called fundamental rights are not in the Constitution. So, and then he said, he basically said, let's go back and change all these other cases that were wrong, just like we're overturning Roe v. Wade. That's, he kind of, if it was a novel we're reading, it's like a foreshadowing that he wants to overturn, like same-sex marriage is and some of these other laws. Okay, now, the next order of business is this. It's kind of like where do we go from here? And kind of like, what's the debate or how, not the debate, but I laugh only because I remember in high school, this was like a debated topic in high school, the abortion, death penalty, things like that, gun rights. And it's like, I'm like reliving these high school debates, right? Anyway, so where do we go from now? Okay, the first thing is we got to have something about this settled law because the Constitution is not being rewritten. I think that the stare decisis has to be, I think that because if it's that easy, I guess, to overturn 50 years of law, if it's that easy, again, the court didn't say it's easy. They said you could only overturn well-settled law if there's a grave injustice, something akin to segregation, segregating schools and hospitals, right? Only if it's that bad, then you could overturn the stare decisis and overturn a previous Supreme Court case. And then that, okay. So I think that we gotta like come up with something like, or make it even tougher to overturn the law, because what's going to happen now is clear, right? These justices one day will die, I think, right? They seem to live a long time, but they will die one day. I mean, for better or worse. I'm not saying, I want them to die. I'm just saying, and then eventually we're going to have different Supreme Court justices. So what's going to happen every like 10, 15, 20 years, everything just changes because the new justices think that, no, that was a fundamental right. I think it was something we need to protect. So I will overturn the case that overturned Roe v. Wade. Right? So that's going to be kind of weird because the United States Supreme Court is not supposed to, they're supposed to interpret the Constitution and the Constitution is not changing. So why are the laws, why are their opinions changing? So I think that one, there has to be some sort of reform, I think, of the way the Supreme Court is done. Because, at this point, we might as well just vote, right? We might as well just have a vote or something, because that's kind of what's happening. A president could appoint someone and that he or she knows is going to rule this way or that way. So it's just, so I think there's been a lot of legitimacy of the Supreme Court being questioned right now. So as lawyers, it's like, that's a no, because it's the Supreme Court, all throughout law school, it's like, that is the highest, thing, honor. The next order of business, and this one is clear, that the Supreme Court did not make abortion illegal. It did not go so far as to say these unborn babies have the right to not be killed. I don't know, right? They don't have that right. They didn't say that. The reason why I say that is because where do we go from now? Every state could make a law that says abortions are legal, okay? So this Supreme Court, like I said, it did not state that abortions are a fundamental right. That it's a fundamental right of the unborn to not be aborted, okay? They never said that. So every state could still pass a law that says abortion is legal, okay? So that won't be changed. So I think the concern is obviously the states that will now pass laws saying we're going to ban abortions in every way. I think that it's going to be I don't think states can pass a law saying if you leave this state to go get an abortion, that's a crime, because that's a different thing. That's like a jurisdictional issue, and I can't see that one being upheld. But I think then the only thing we can go from here, if for the people that are pro-choice, they just have to get votes, I guess, in the states where abortion is going to be banned, votes that say abortion is allowed, okay? Because otherwise, if a state passes something, you're not going to get reprieve from the courts anymore because of this decision, right? And so that's going to be the way it is. You just have to go to the state legislatures, and that's what this court ruled. We'll see how that goes. I know one thing's for sure. This is not going to be the end of the debate, right? All right. Wow. Let's, as always, I love talking to everyone. Most importantly, I love hearing from you good folks. Please give me a call or send me an email. Here's my information. You can call me 619-672-1741. I love hearing from you. Okay. And as always, thank you for being here, and I'll see you folks next week in Run It By My Lawyer.